Before we get started, please go over to Amazon.com and grab a copy of my book, Education and Justice. If you have an African-American son in public school, you need this book because I teach you the many ways that public schools mistreat African-American boys and what you can do to help your son. So go over there and get your copy immediately. So what I'm going to do in this video is I'm going to read Justice Jackson's dissenting opinion in the Trump v. CASA Birthright Citizenship case. What she said is so critical, so urgent for our nation, and especially for African-American people. Justice Jackson is going to really break things down for us to let us know where we are. Now, what you got to do is you got to discipline yourself to read about 8 pages with me, because I'm going to read it from the start of it to the finish. Okay? Now, remember that it was a 6-3 case. Those 6 conservatives essentially held that lower federal courts cannot issue nationwide injunctions against Trump. So even if Trump is attempting to do something unlawful, unconstitutional, illegal, the lower federal courts can only issue an injunction related to the people who filed the lawsuit. But they can no longer, as they have in the past, issue a nationwide injunction. And by the way, injunction just simply means a stop or a stay of some action. All right? So they can no longer do that. And as a result of that, and Justice Jackson is going to explain it to you very graphically and how it impacts us as African Americans, the result of that is Trump can do unconstitutional, unlawful, illegal things unless someone files a class action lawsuit to stop him. And those can take time because you got to get them certified. A judge has to approve class action lawsuits. So in my last video, I said to you that Trump can unlawfully start deporting African American, Black American, whatever term you want to use. And not only Black Americans, but white Americans, Asian Americans, and so on. Because courts no longer have the tool to stop him nationwide. He can be stopped in this one court, this one district, but then he can continue doing that unlawful thing around or across the country. That's what happened in this case that has caused such an uproar. Are you with me? Now, again, a 6-3 opinion. The 6 conservatives, they all back that holding up. And then the 3 progressive liberals, whatever you want to call them, they disagreed and wrote a dissenting opinion. Justice Sotomayor wrote what you could consider the major dissenting opinion. And then Justice Jackson, she also wrote a dissenting opinion. And Justice Kagan, she joined Justice Sotomayor's opinion. Now, Justice Jackson's opinion is so sharp and so on point that Justice Amy Coney Barrett, who wrote the majority opinion, she cast some shade on Justice Jackson. And the reason for that was because Justice Jackson's opinion, it pulls no punches and it lays it out tight and right. But a whole lot of people around the country are not hearing it. They don't know much about it. And I'm going to use my platform to try to give it a wider audience so more people can hear what she's saying, because this truly is a warning to America, but especially Black America And you'll see why in just a moment. Now, before we go over there, just a little bit about who she is. Ketanji Brown Jackson, born September 14th, 1970, earned her AB from Harvard Radcliffe in 1992 and JD, Juris Doctor, from Harvard Law School in 1996. She clerked for Justice Breyer. She worked in, and that's Stephen Breyer, one of the Supreme Court justices. She worked in private practice, the U.S. Sentencing Commission, and as a federal public defender. And that's significant by itself because she got real-world experience out there fighting for our community. And she brings that to the table, and none of the rest of them has that type of experience. Obama appointed her to the U.S. District Court for D.C. in 2013. Biden appointed her to the D.C. Circuit in 2021 and to the Supreme Court in 2022. She took her seat on June 30th, 2022. So that's who she is. Let's get to her dissenting opinion. All right, again, it's about 8 to 9 pages. Discipline yourself, you all, and read this with me. You're going to see how serious her warning is for our nation. All right. So she says, I agree with every word of Justice Sotomayor's dissent. I write separately to emphasize a key conceptual point. The court's decision to permit the executive meaning the president, to violate the Constitution with respect to anyone who has not yet sued is an existential threat to the rule of law. That is so significant. She is saying here, by allowing Trump to do what is in violation of the United States Constitution, is an existential, a presently existing threat to the rule of law. And without the rule of law, we got a king. We have a dictator, an autocrat. All right, that's what she's saying. She goes on to say, it is important to recognize that the executive's bid to vanquish so-called universal injunctions is at bottom a request for this court's permission to engage in unlawful behavior. All right, so I'm not going to explain every sentence, but everything she says is so juicy, it's tempting. So what she's saying here is when Trump asked the court to stop judges from issuing universal injunctions, he was essentially asking them to allow him or to grant him permission to engage in unlawful behavior. In other words, behavior that violates the Constitution. When the government says do not allow the lower courts to enjoin executive action universally as a remedy for unconstitutional conduct, what it is actually saying is that the executive wants to continue doing something that a court has determined violates the Constitution. Please allow this. That is some solicitation. With this ruling today, the majority largely grants the government's wish. But in my view, if this country is going to persist as a nation of laws and not of men, the judiciary has no choice but to deny it. Stated simply, what it means to have a system of government that is bounded by the law is that everyone is constrained by the law, no exceptions. And for that to actually happen, courts must have the power to order everyone, including the executive or the president, to follow the law, full stop. To conclude otherwise is to endorse the creation of a zone of lawlessness within which the executive has the prerogative to take or leave the law as it wishes, and where individuals who would otherwise be entitled to the law's protection become subject to the executive's whims instead. Let me explain that. She's saying that this decision allows Trump, at his whims and his prerogatives, to obey the laws that protect us or not obey the laws that protect us, including deporting American citizens. Justice Sotomayor said in a previous opinion that anyone can be deported anywhere. There's no exception to that under this case. Some folks say, well, we were born here. We are foundational Black Americans, so therefore we can't be deported. These folks don't understand the law who say that. Under this case, anyone, as Justice Sotomayor said, anyone can be deported anywhere under this particular ruling, which basically unleashes Trump. All right? The majority cannot deny that our Constitution was designed to split the powers of a monarch between the governing branches to protect the people. Nor is it debatable that the role of the judiciary in our constitutional scheme is to ensure fidelity to law. But these core values are strangely absent from today's decision. Focusing on inept comparisons to impotent English tribunals, the majority ignores the judiciary's foundational duty to uphold the Constitution and laws of the United States. The majority's ruling thus not only diverges from first principles, it is also profoundly dangerous since it gives the executive the go-ahead to sometimes wield the kind of unchecked, arbitrary power the founders crafted our Constitution to eradicate. The very institution our founding charter charges with the duty to ensure universal adherence to the law now requires judges to shrug and turn their backs to intermittent lawlessness. With deep disillusionment, I dissent. Those are profound words. She goes on to say, to hear the majority tell it, this suit raises a mind-numbingly technical query. Are universal injunctions sufficiently analogous to the relief issued by the High Court of Chancery in England at the time of the adoption of the Constitution and the enactment of the original Judiciary Act to fall within the equitable authority Congress granted federal courts in the Judiciary Act of 1789? But that legalese is a smokescreen. It obscures a far more basic question of enormous legal and practical significance, which is, my addition, may a federal court in the United States of America order the executive to follow the law? So she's saying that the majority, Justice Barrett, went into deep history about English courts and the King of England and came out of that and said that there's no basis for universal injunctions. Justice Jackson says that is all a smokescreen. What this bottoms out to, as she said, may a federal court in the United States of America order the executive to follow the law. Can a federal court order Trump to follow the Constitution? She said that is the basis of this case. That's the question. Not all this other stuff about courts in England back 300, 400 years ago. But does federal courts today have the authority to say to the executive branch, stop it and follow the law? So she goes on to say, to ask this question is to answer it. In other words, the answer is obvious. In a constitutional republic such as ours, a federal court has the power to order the executive to follow the law, and it must. It is axiomatic that the Constitution of the United States and the statutes that the people's representatives have enacted govern in our system of government. Thus, everyone from the president on down is bound by law. By duty and nature, federal courts say what the law is if there is a genuine dispute and require those who are subject to the law to conform their behavior to what the law requires. This is the essence of the rule of law. Do not take my word for it. Venerated figures in our nation's history have repeatedly emphasized that the essence of our free government is leave to live by no man's leave underneath the law, to be governed by those impersonal forces which we call law. In other words, we're all bound by the law. Our government is fashioned to fulfill this concept so far as humanly possible. That familiar adage is more than just mere rhetorical flourish It is the rejection in positive terms of rule by fiat, whether by fiat of government or private power. Indeed, constitutionalism has one essential quality. It is a legal limitation on government. It is the antithesis of arbitrary rule. Its opposite is despotic government, the government of will instead of law. So she just simply said right there that we don't, as a nation, our government doesn't rule by fiat, by executive orders, by hunches and whatever they want to do, divorced from the rule of law. Is what she's trying her best to stress. She goes on to say, those who birthed our nation limited the power of government to preserve freedom. As they knew all too well, constant experience shows us that every man invested with power is apt to abuse it and to carry his authority as far as it will go. But the founders reasoned that the vice of human ambition could be channeled to prevent the country from devolving into despotism. Ambition could be made to counteract ambition. If there were, say, a constitution that divided power across institutions in such a manner as that each may be a check on the other, then it could be possible to establish government by and for the people, and thus stave off autocracy. She knows exactly what is facing us if they got this wrong, and they got it wrong. Through such separated institutions, power checks power. Our system of institutional checks thus exists for a reason, so that the private interests of every individual may be a sentinel over the public right, All right, then she goes on to say, the distribution of power between the judiciary and the executive is of particular importance to the operation of a society governed by the law, made up of free, impartial, and independent judges and justices. The judiciary checks the political branches of government by explaining what the law is and securing obedience. The federal courts were thus established not only to decide upon the controverted rights of the citizens as against each other, but also upon rights and controversy between them and the government. Quite unlike a rule of kings governing system and a rule of law regime, nearly every act of government may be challenged by an appeal to law. In this country, the executive does not stand above or outside of the law. Consequently, when courts are called upon to adjudicate the lawfulness of the actions of the other branches of the government, the judiciary plays an essential part of the democratic process. Were it otherwise, were courts unable or unwilling to command the government to follow the law, they would sanction a tyranny. That has no place in a country committed to well-regulated liberty and the protection of personal rights. It is law and law alone that saves a society from being rent by internecine strife or ruled by mere brute power, however disgusted. The power to compel the executive to follow the law is particularly vital where the relevant law is the Constitution. When the executive transgresses an act of Congress, there are mechanisms through which Congress can assert its check against the executive unilaterally, such as, for example, asserting the power of the purse. But when the executive violates the Constitution, the only recourse is the courts. Eliminate that check, and our government ceases to be one of limited power. After all, a limit that does not confine the person on whom it is imposed is no limit at all. With that background, we can now turn to this suit and focus on the ways in which the majority's ruling undermines our constitutional system. Justice Sotomayor has laid out the relevant facts, and I will not repeat what she has said. It suffices for my purposes to reiterate that before these applications arrived here, 3 district courts had concluded that Executive Order number 14160 which attempts to alter the Constitution's express conferral of citizenship on all who are born in this nation, likely violates the Constitution. Those courts each thus enjoin the executive from enforcing that order anywhere against anyone. 3 courts of appeals then declined to upset these injunctions during the pendency of the government's appeal. The majority now does what none of the lower courts that have considered Executive Order number 14160 would do. It allows the executive's constitutionally dubious mandate to go into effect with respect to anyone who is not already a plaintiff in one of the existing legal actions. Notably, the court has not determined that any of the lower courts were wrong about their conclusion that the executive order likely violates the Constitution. The executive has not asked us to rule on the lawlessness of Executive Order number 14160, but the majority allows the executive to implement this order, which lower courts have so far uniformly declared likely unconstitutional nonetheless. Given the critical role of the judiciary in maintaining the rule of law, it is odd to say the least that the court would grant the executive's wish to be freed from the constraints of law by prohibiting district courts from ordering complete compliance with the Constitution. But the majority goes there. Now notice I have this underlined, this next sentence. But the majority goes there. It holds that even assuming that Executive Order number 14160 violates the Constitution, federal courts lack the power to prevent the executive from continuing to implement that unconstitutional directive. Now here, I got to explain what she said because I have it underlined. This is really important. And this is where all Americans are in jeopardy at this point. So she says that even if the executive order violates the Constitution, federal courts lack the power to prevent the executive from continuing to implement that unconstitutional directive. And so that brings me to the video I made yesterday where I said Black Americans can be deported because there's no one to stop Trump from doing so. So if he issues an executive order that says we are deporting Black Americans, Asian Americans, white Americans, or whomever, because of this or that reason, federal courts couldn't stop him. And we are not exempt from that. We're not exempt. No matter what anyone tells you, no matter what pro-Black imposter tells you otherwise, we as Black Americans are not exempt from Trump's lawlessness. In fact, not only are we not exempt, we're more vulnerable. And she's going to bring that out in just a moment. Let's go back. As I understand the concern, in this clash over the respective powers of 2 coordinate branches of government, the majority sees a power grab, but not by a presumably lawless executive choosing to act in a manner that flouts the plain text of the Constitution. Instead, to the majority, the power-hungry actors, wait for it, the district courts. In the majority's view, federal courts only have the power to afford the plaintiff complete relief. In the cases brought before them, they can do nothing more. And the majority thinks a so-called universal injunction, that is, a court order requiring the executive to follow the law across the board and not just with respect to the plaintiff, grants relief to non-parties. Therefore, the majority reasons issuing such orders exceeds district courts' authority. So many questions arise. The majority's analysis is fully interrogated, encountered in Justice Sotomayor's dissent. My objective is to expose the core conceptual fallacy underlying the majority's reasoning, which to me also tends to demonstrate why and how today's ruling threatens the rule of law. The pillar upon which today's ruling rests is the majority's contention that the remedial power of the federal courts is limited to granting complete relief to the parties. And the majority's sole basis for that proposition is the practice of the High Court of Chancery in England. But this cramped characterization of the judiciary's function is highly questionable when it comes to suits against the executive. That is, even if the majority is correct that the courts in England at the time of the founding were so limited, I have my doubts. Why would courts in our constitutional system be limited in the same way? The founders of the United States of America squarely rejected a governing system in which the king ruled all, and all others, including the courts, were his subordinates. In our constitutional-centered system, the people are the rulers. We have the rule of law, so it makes little sense to look to the relationship between the English courts and the king for guidance on the power of our nation's judiciary vis-a-vis its executive. See the Federalist number 69 at 416. All right, she goes on to say, indeed, it is precisely because the law constrains the government in our system that the judiciary's assignment is so broad, per the Constitution. Federal courts entertain suits against the government claiming constitutional violations. Thus, the function of the courts, both in theory and in practice, necessarily includes announcing what the law requires in such suits for the benefit of all who are protected by the Constitution, not merely doing our relief to injured private parties. Put differently, the majority views the judiciary's power through an aperture that is much too small, leading it to think that the only function of our courts is to provide complete relief to private parties. Let me explain what she's saying there. You keep saying complete relief. So Amy Coney Barrett, she wrote in the majority opinion that federal courts may issue universal injunctions if they are required to give the plaintiffs in a lawsuit complete relief. Other than that, they can only issue universal injunctions in a class action lawsuit. That is a severe limitation on when federal courts can issue universal injunctions. Again, only when it's required to give the plaintiffs complete relief or part of a certified class action lawsuit. That's what she's saying. Sure, federal courts do that, and they do it well. But they also diligently maintain the rule of law itself. When it comes to upholding the law, federal courts ensure that all comers, that is, everyone to whom the law applies and over whom the court has personal jurisdiction, including and perhaps especially the executive, know what the law is, and most important, follow it. Still, upon reading the court's opinion, the majority's foundational mistake in mischaracterizing the true scope and nature of a federal court's power might seem only marginally impactful. Indeed, one might wonder, why all the fuss? After all, the majority recognized that district courts can still issue universal injunctions in some circumstances. It even acknowledges that the lower courts may reimpose the same universal injunctions at issue in these cases if the courts find on remand that doing so is necessary to provide complete relief to the named plaintiffs. From the standpoint of outcomes, that's all welcome news. But as I explained below, from the perspective of constitutional theory and actual practice, disaster looms. What I mean by this is that our rights-based legal system can only function properly if the executive and everyone else is always bound by law. Today's decision is a seismic shock to that foundational norm, allowing the executive to violate the law at its prerogative with respect to anyone who has not yet sued carves out a huge exception, a gash in the basic tenets of our founding charter that could turn out to be a mortal wound. What is more, to me, requiring courts themselves to provide the dagger by giving them the imprimatur to the executive branch's intermittent lawlessness makes a mockery of the judiciary's solemn duty to safeguard the rule of law. Do remember, the executive has not asked this court to determine whether Executive Order number 14160 complies with the Constitution. Rather, it has come to us seeking the right to continue enforcing that order regardless. That is, even though 6 courts have now said the order is likely unconstitutional. What the executive wants, in effect, is for this court to bless and facilitate its desire to operate in 2 different zones moving forward. One in which it is required to follow the law because a particular plaintiff has secured a personal injunction prohibiting its unlawful conduct, and another one in which it can choose to violate the law with respect to certain people, those who have yet to sue. Now, I want you to pay very close attention to what we're about to read. And this is why we as African Americans are particularly vulnerable to this case. So she says, do remember, in the first zone, law reigns. For the named plaintiffs in the suits before us, for example, the lower court's determination that Executive Order number 14160 is likely unconstitutional and cannot be implemented has teeth. Per the court's orders, the executive is prohibited from denying citizenship to the offspring of the named plaintiffs. Within this zone, the court's rule of decision, that Executive Order number 14160, is likely unconstitutional, applies. Watch this. But with its ruling today, the majority endorses the creation of a second zone, one in which that rule of decision has no effect. In this zone, which is populated by those who lack the wherewithal or ability to go to court, all bets are off. Now watch this. I have it underlined. There is no court-issued mandate requiring the executive to honor birthright citizenship in compliance with the Constitution. So the people within the zone are left to the prerogatives of the executive as to whether their constitutional rights will be respected. Let's read it again. There is no court-issued mandate requiring the executive to honor birthright citizenship in compliance with the Constitution. In other words, there is nothing forcing Trump to respect birthright citizenship. So Trump can say through an executive order that any of us, any group, are no longer citizens merely because we were born in this country. Now, that is coming straight from Justice Jackson. So she talks about 2 different zones. One zone, yes, restricting the president with respect to those folks who brought their lawsuit. But the other zone, no. There's nothing restricting the president there, so he can enforce his unlawful, unconstitutional executive order, if that's what the case be. She goes on to say, it does not matter what 6 federal courts have said about Executive Order number 14160. Those courts are powerless to make the executive stop enforcing that order altogether. In effect, then, that powerlessness creates a void that renders the Constitution's constraints irrelevant to the executive's actions. Of course, the executive might choose to follow the law in this zone as well, but that is left to his discretion. And the Solicitor General has now confirmed that in the absence of a personal injunction secured by a particular plaintiff, This executive's view is that compliance with lower courts' rulings on matters of constitutional significance is optional. She goes on to say, I am not the first to observe that a legal system that operates on two different tracks, one of which grants to the executive the prerogative to disregard the law, is anathema to the rule of law. Thus, the law-free zone that results from this court's near elimination of universal injunctions is not an unfamiliar archetype. Also eerily echoing history's horrors is the fact that today's prerogative zone is unlikely to impact the public in randomly distributed manner. I want you to listen closely here. Those in the good graces of the executive have nothing to fear. The new prerogative that the executive has to act unlawfully will not be exercised with respect to them. Those who accede to the executive's demands, too, will be in the clear. The wealthy and the well-connected will have little difficulty securing legal representation, going to court, and obtaining injunctive relief in their own name if the executive violates their rights. Now, I want to go back up where she says, those in the good graces of the executive have nothing to fear. From what I can tell, that is where these folks who call themselves foundational Black Americans, that's where they feel that Trump would never deport them, that Trump would never do that. He can't do that. He won't do that because we're in the good graces of the president. He has actually said that the citizenship clause of the 14th Amendment is for the babies of slaves. So he has singled us out, and we don't have any fear. Trump likes us. That is as naive as me telling you I will sell you the Brooklyn Bridge for $1. That's how naive that is. When did we start as a people taking the word of white supremacists? When did we start believing the word of a man who is implementing a white supremacist agenda, Project 2025? Trump absolutely says things, throws things out there to make such people believe that he's with them. And why does he do that? For votes, for support, until he doesn't need them anymore. And right now, a lot of those folks' votes are still needed for the 2026 midterms. So yes, he'll hang that carrot out there. And these gullible individuals, sadly and unfortunately, will fall for it again, like they fell for it in 2016. By voting for Trump or not voting at all. And let me just show you some of the fallout from that. Let me just show you some of the fallout from that affects us today. And that is Neil Gorsuch, Amy Coney Barrett, Brett Kavanaugh. Trump put those three folks on the court. And it's those three folks, and I told you this, that today sided with the majority and will continue to side with Trump so that he can continue implementing this white supremacist Project 2025 agenda. There were consequences then, and there will be consequences now. Because you never, ever, ever, ever trust a rattlesnake. Never. I guess you got to be from the country to understand that. But you don't take a rattlesnake in your arms and try to kiss it. It will bite you every time. Now, let's finish this up. Consequently, the zone of lawlessness the majority has now authorized will disproportionately impact the poor, the uneducated, and the unpopular. Those who may not have the wherewithal, the money, the resources to lawyer up. Those that get snatched up, those that Trump target, who don't have the money to hire some lawyer to fight for him. Yet they voted for him. Yet they supported him. And will all too often find themselves beholden to the executive's whims. This is yet another crack in the foundation of the rule of law, which requires equality and justice in its application. In the end, though, everyone will be affected because it is law's even-handed application to minorities as well as majorities, to the poor as well as the rich, that hold society together. So she's saying that this opinion created two different legal systems, two zones, two tracks, one for the well-connected, one for the rich, then one for the rest of us, for the rest of the country. This is really serious, and she really broke it down. The majority skips over these consequences. No one denies that the power of federal courts is limited both by Constitution and by Congress, but the majority seems to forget or ignores that the Constitution and Congress also limit the power of the executive. In addition, it is indisputable that the executive's power to leverage physical force in a manner that directly threatens to deprive people of life, liberty, and property creates uniquely harmful risk when unconstrained by law. But the majority today roots its holding in a purported statutory limitation, not a constitutional one. And as I've explained, our Constitution gives federal courts the authority to order the executive to stop acting unlawfully. To the extent Congress has attempted to strip federal courts of that power via the Judiciary Act, and to be clear, I do not think it has, for the reasons Justice Sotomayor discusses, it is powerless to do so. The bottom line is this: if courts do not have the authority to require the executive to adhere to law universally, a dual-track system develops in which courts are ousted as guardians in some situations, and compliance with law sometimes becomes a matter of executive prerogative. But there can be no free society without law administered through an independent judiciary. If one man, even a very important man, and even a democratically elected man, can be allowed to determine for himself what is law, every man can. That means first chaos, then tyranny. This leads me to another potentially destructive aspect of today's decision: the court's dismissive treatment of the solemn duties and responsibilities of the lower courts. Sworn judicial officers must now put on blinders and take a see-no-evil stance with respect to harmful executive conduct, even though those same officials have already announced that such conduct is likely unconstitutional. Yes, certain named plaintiffs have brought particular lawsuits seeking protection of their legal rights, but their claim is that Executive Order number 14160 violates the Constitution. If the court agrees with them, why on earth must it permit that unconstitutional government action to take effect at all? I've already explained why the majority's answer, because the court is powerless to do anything but give complete relief to those parties, is wrong in terms of the actual scope of federal court's authority. I now observe that this response also erroneously suggests that a court does something wrongful when it imposes a universal injunction in a single plaintiff's lawsuit, akin to giving a windfall to those who do not deserve the law's protection because they have not sued. This way of conceptualizing universal injunctions mistakes that remedy for the unearned spoils of particular adversarial engagements rather than a necessary tool employed to defend the Constitution by reinforcing pre-existing rights. Here's what I mean. Our Constitution indisputably confers individual rights that operates as unequivocal protections against government action. Thus, a constrained executive, that is one who is bound by the Constitution not to violate people's rights, is a public benefit guaranteed to all from the start without regard to the nature or existence of any particular enforcement action. Properly understood, then, when the executive violates those pre-existing rights in a non-particularized manner, a universal injunction merely restores what the people were always owed. That remedy does not improperly distribute an unearned benefit to those who did not have the temerity to secure it for themselves by filing a lawsuit. Or consider it the other way. When a court is prevented from enjoining the executive universally after the executive establishes a universal practice of stripping people's constitutional rights, anyone who is entitled to the Constitution's protection but will instead be subjected to the executive's whims is improperly divested of their inheritance. The Constitution is flipped on its head, for its promises are essentially nullified. So rather than having a governing system characterized by protected rights, the default becomes an executive that can do whatever he wants to whomever he wants, unless and until each affected individual affirmatively invokes the law's protection. Now, you know I got to read that again. She says, so rather than having a government system characterized by protected rights, the default becomes an executive that can do whatever it wants to whomever it wants, unless and until each affected individual affirmatively invokes the law's protection. A concrete example helps to illustrate why this turnabout undermines the rule of law. Imagine an executive who issues a blanket order that is blatantly unconstitutional, demanding, say, that any and all of its political foes be summarily and indefinitely incarcerated in a prison outside the jurisdiction of the United States, without any hearing or chance to be heard in court. Shortly after learning of this edict, one such political rival rushes into court with his lawyer, claims the executive's order violates the Constitution, and secures an injunction that prohibits the executive from enforcing that unconstitutional mandate. The upshot of today's decision is that, despite that rival's success in persuading a judge of the unconstitutional nature of the executive's proclamation, the court's ruling and injunction can only require the executive to shelve any no-process incarceration plan that targets that particular individual, the named plaintiff. The executive can keep right on rounding up his other foes, despite the court's clear and unequivocal pronouncement that the executive order is unlawful. The majority today says that unless and until the other political rivals seek and secure their own personal injunctions, the executive can carry on acting unconstitutionally with respect to each of them, as if the Constitution's due process requirement does not exist. For those who get to court in time, their right not to be indefinitely imprisoned without due process will be protected. But if they are unable to sue or get to the courthouse too late, the majority says, oh well, there's nothing to be done, despite the fact that their detention without due process is plainly prohibited by law. A Martian arriving here from another planet will see these circumstances and surely wonder, what good is the Constitution then? What really is this system for protecting people's rights if it amounts to this, placing the onus on the victims to invoke the law's protection and rendering the very institution that has the singular function of ensuring compliance with the Constitution powerless to prevent the government from violating it. Those things Americans call constitutional rights seem hardly worth the paper they're written on. These observations are indictments, especially for a nation that prides itself on being fair and free. But after today, that is where we are. What the majority has done is allow the executive to nullify the statutory and constitutional rights of the uncounseled, the undersourced, and the unwary by prohibiting the lower courts from ordering the executive to follow the law across the board. Moreover, officers who have sworn an oath to uphold the law are now required to allow the executive to blatantly violate it. Federal judges pledge to support and defend the Constitution of the United States against all enemies, foreign or domestic. They do not agree to permit unconstitutional behavior by the executive or anyone else, but the majority forgets or ignores this duty, eagerly imposing a limit on the power of courts that, in essence, prevents judges from doing what their oaths require. I view the demise of the notion that a federal judge can order the executive to adhere to the Constitution, full stop, as a sad day for America. The majority's unpersuasive effort to justify this result makes it sadder still. It is the responsibility of each and every jurist or judge to hold the line. But the court now requires judges to look the other way after finding that the executive is violating the law, shamefully permitting unlawful conduct to continue unabated. Today's ruling, this is the last page. Today's ruling thus surreptitiously stymies the judiciary's core duty to protect and defend constitutional rights. It does this indirectly by preventing lower courts from telling the executive that it has to stop engaging in conduct that violates the Constitution. Instead, now a court's power to prevent constitutional violations comes with an asterisk. A court can make the executive cease its unconstitutional conduct, but only with respect to the particular plaintiffs named in the lawsuit before them, leaving the executive free to violate the constitutional rights of anyone, all of us, and everyone else. Make no mistake, today's ruling allows the executive to deny people rights that the founders plainly wrote into our Constitution, so long as those individuals have not found a lawyer or asked the court in a particular manner to have their rights protected. This perverse burden shifting cannot coexist with the rule of law. In essence, the court has now shoved lower court judges out of the way in cases where executive action is challenged, and has gifted the executive with the prerogative of sometimes disregarding the law. As a result, the judiciary, the one institution that is solely responsible for ensuring our republic endures as a nation of laws, has put both our legal system and our system of government in grave jeopardy. The accretion of dangerous power does not come in a day, but it does come from the generative force of unchecked disregard of the restrictions that fence in even the most disinterested assertion of authority. By needlessly granting the government's emergency application to prohibit universal injunctions, the court has cleared a path for the executive to choose law-free action at this perilous moment for our Constitution, right when the judiciary should be hunkering down to do all it can to preserve the law's constraints. I have no doubt that if judges must allow the executive to act unlawfully in some circumstances, as the court concludes today, executive lawlessness will flourish. And from there, it is not difficult to predict how this all ends. Eventually, executive power will become completely uncontainable, and our beloved constitutional republic will be no more. Perhaps The degradation of our rule of law regime would happen anyway. But this court's complicity in the creation of a culture of disdain for lower courts, their rulings, and the law, as they interpret it, will surely hasten the downfall of our governing institutions, enabling our collective demise. At the very least, I lament that the majority is so caught up in minutiae of the government's self-serving, finger-pointing arguments that it misses the plot. And there is a plot. And this plot has been in the making for years. For years. We could say, actually, for 400 years. But this specific plot, at least the last decade. And the U.S. Supreme Court is a part of the plot, obviously. The majority forgets or ignores that with all its defects, delays, and inconveniences, men have discovered no technique for long-preserving free government except that the executive be under the law and that the law be made by parliamentary deliberations. Tragically, the majority also shuns this prescient warning. Even if such institutions may be destined to pass away, it is the duty of the court to be last, not first, to give them up. What a powerful dissent. Written by Justice Ketanji Brown Jackson. Powerful. And I had to read it. I had to read every single bit of it. And those of you who stayed through it all, I pray you understand it. Thank you for watching it. I see people all the time listening to foolishness for hours on end. So you did yourself a lot of good and those around you to have stayed here and to listen and watch me read Justice Jackson's dissenting opinion. It is powerful. And unfortunately, what it tells us is Trump has been unleashed with this ruling. Now to get universal injunctions, if you can't get one from the lower court judge because of the difficulty of class action lawsuits, or because the lower court judge just doesn't agree with you, let's say, for example, you go to a court that has a Trump-appointed judge and they just don't agree with you and don't give you a universal injunction, okay? Or you can't get your class action lawsuit certified, guess where you got to get that universal injunction? From SCOTUS. And that depends on SCOTUS even accepting your case, which they don't have to. And even if they did, you got to convince 6 right-wing judges to issue a universal injunction against Trump. And even if you did that, it could take a long time and the damage be already done. That's where we are, folks. And that's what she laid out in her dissenting opinion. I'm Reverend and Civil Rights Attorney Augustus Corbett. Thank you for watching this video. And as always, stay woke.